See, anybody who tries to look at the history of this particular provision will understand two things. One, what we have as Section 295A today in the Indian Penal Code is not a provision that was introduced by the Indian Parliament, so to speak. This was introduced by the Indian Legislative Assembly in 1927. And therefore, for all practical purposes, this is a colonial imposition. There is no running away from that at all. And if the Supreme Court can take cognizance of the fact that Section 377 was a colonial imposition, it's equally possible for us to come to the conclusion that this is equally a colonial imposition. Now, a bit of the history becomes very, very important to understand that the situations which triggered the promulgation of this legislation continue to survive even today, and how the nature of this entire provision and the manner of its implementation, although biased and skewed, is consistent with its history. Okay. So Swami Shraddhanand, along with other Arya Samajis, was effectively trying to reconvert the Muslims of Pakistan, or what we know as Pakistan today, West Punjab. And therefore, there were reactions from the Muslim community at that point in time. And that reaction, effectively, one of the most important reactions which triggered a response was they started circulating pamphlets where Devi Sita was slandered in the worst of language possible. And therefore, unlike today, let's say the Hindu side then was perhaps more conscious of its Hindu identity, and therefore they responded in kind. And that led to the publication of the book called Rangila Rasool. And when Rangila Rasool was published, it led to, let's say, a certain legal proceeding. And in the legal proceeding, during the course of the legal proceeding, the publisher of the book, I suspect, was murdered or assassinated by this gentleman called Ilmuddin. Okay. And at his, let's say, at his funeral, you had the leading lights of the Pakistan movement who landed there, including, I think, Jinnah and others, who celebrated his act and called him a Ghazi. And we all know what that reference ultimately means and what is the historical significance of it. Now, the only provision that was available under the legal framework then was Section 153A, which continues to be present even today, which is meant to prevent any promotion of enmity between two communities. Now, promotion of enmity between two communities is not the same as, let's say, going after the religious belief of one particular community. So therefore, since there was no specific provision that directly dealt with the issue of blasphemy or insult to religious sentiments, a Muslim legislator pointed this out in the Indian Legislative Assembly to basically say that the courts have recognized that there is a legal vacuum. So what is the British Indian government going to do to fill up this legal vacuum? To address these concerns, which were specifically Muslim in nature because they wanted a provision that dealt with blasphemy and deterred blasphemy, Section 295A was introduced through the Criminal Amendment Act of 1927. So today, when we end up asking, why is this provision being used only in one particular fashion? Why is this provision constantly available against one community and not to another community? The very intention was to address the concerns of one particular community which had belief in blasphemy. Okay, and therefore, you have a situation where that legacy has continued, coupled with the fact that the fabric of the Indian state has always been anti-indigenous in nature since 1947. And since it has been colonial in its mindset, it has continued with that particular mindset, which effectively is the legacy of the European. Third, while there are legal provisions and there could be the law, there is also the question of street veto. And therefore, one particular community's ability to constantly enforce the street veto would mean that the law as well as the street veto go against the indigenous sentiments. And therefore, my fundamental question was, a colonial government passes a legislation with respect to protection of a certain religious sentiment, which has no basis in Indic civilizational fabric. And therefore, today we have to revisit this and ask ourselves, what is the basis for this? Why do we need to push it? So broadly, my position is that blasphemy laws within the canvas of an Indic civilizational perspective, frankly, is irrelevant and is ridiculous. And perhaps we need to look and ask ourselves, has this particular provision achieved the goals that it was meant to? And has it been used in a neutral fashion despite its neutral language? If it is not, then perhaps we must scrap it and we must have a slightly different perspective about blasphemy and other issues. It's surprising that we constantly look to different sides of the Atlantic when it comes to free speech, but when it comes to blasphemy, we seem to be protecting certain sentiments. So that's a beautiful, let's say, example of Indian secularism at play.
Mm-hmm. But then what will be your take on this entire Munawar Faruqui saga?
See, let me put it to you this way. I am not someone who believes that you must necessarily slander or there is a line that can be drawn between criticism, analysis, and plain malicious nonsense. Okay. Now, even then, malicious nonsense for all practical purposes must be responded to with malicious nonsense. However, if somebody tells me that he is talking, you talk back, they don't realize that there is a certain amount of street veto that is present from the other side. And fundamentally, if the identity recognizes the concept of other and the concept of other is central to its identity, there is no running away from the fact that I am the other and I have to respond as the other. I have no other option. I am the kafir, I am the infidel, I am the idol worshipping idiot. Okay. So for all practical purposes, I have been othered in the basic, let's say, constitution of a certain mentality. So if that is the case, I might as well recognize that reality and I might as well respond to it, as opposed to saying that I will continue to subscribe to my rules of engagement. The rules of engagement of these two sections are very, very different. The fundamental, let's say, ontology, epistemology, theology, everything is different. So whether we like it or not, we are looking at a reinstatement or, let's say, a restatement of the two-nation theory. This is the reality. Okay. We have been running away from this particular concept since 1947. It is beginning to prove us wrong, and it is beginning to tell us that whether you subscribe to a single nation theory or whatever it is, first of all, there's no concept of a nation that can be applied to this country. Even if it can be applied to this particular country, there is a clear distinction between two streams of thought, which hasn't changed since the 7th century.
Yeah, so which I often talk about, you have a section of the population in the subcontinent basically owing loyalty or allegiance to a different civilization narrative. And that is manifesting itself in the form of different national boundaries. Correct. And that is why Pakistan and India, the international boundary between the two, is hardest boundary in the world.
Because that's a civilization boundary for all practical purposes.
That is, yeah. So, as someone wrote on Facebook that history will never forgive our courts and police for participating in the shameful persecution of minority citizens on the issue of Munawar Faruqui and on the issue of Kamlesh Tiwari, that history will never forgive us for shamefully participating in hurting the sentiments of the minority community.
So, heads are even, tails Ulus is the argument.
Yeah. So. But then what happens to the free speech, Deepak? You are saying that we have to differentiate between malicious nonsense and criticism. Who decides what is malicious nonsense, what is criticism, and then what happens to the free speech in the country?
See, unfortunately, what has happened is we have given our systems and our institutions, especially the judiciary, the status of pre-Protestant Reformation Roman Catholic Church, which effectively means that they decide everything. Okay. Unfortunately, that is not the manner in which even those jurisdictions which were the origins of this form of government subscribe to. That's not the notion at all. And in India, we have a peculiar concept of democracy, a peculiar concept of separation of powers, and a peculiar understanding of how these things are supposed to work. I'm going with the first principles, assuming that I'm still colonial in my approach. What are the first principles? Public morality, social morality, at the end of the day, is informed through and by an essentialist approach. There is very little nuance that is always possible when it comes to these kind of ideas. And their demographics make the difference. That is the reality. There is no running away from it at all. Public morality, when it comes to, let's say, Europe or let's say America, Europe perhaps is a gone case now, but at least when it comes to America, remains a Christian morality for all practical purposes because it's a Christian majority country, notwithstanding the fact that you may have people who speak Spanish, you may have Mexicans, whoever it may be, but the bulk of the country happens to be Christian in nature. Therefore, there are judgments which clearly say that when it comes to public morality, you look at civilizational identity, cultural identity, certain set of common shared values which are shared by the majority of the people. Okay. Therefore, it goes back to a fundamental question of what is our identity? All of it ultimately pivots only to that particular question. So when it comes to free speech in this country, I would suggest that we draw back, or rather we draw from and pull heavily from what is the scope of free speech that has been permitted as part of the Indic civilization narrative before two forms of colonial Abrahamic monotheistic systems ended up showing up in this country before their advent in this country. That is the period that I draw my cutoff point to for a very clear reason. If you look at the literature of decoloniality, or you look at the literature of even post-colonialism effectively puts a cutoff date of 17th century to 18th century because Industrial Revolution, Enlightenment, that's the period that they refer to. Decoloniality goes to the period of 1490 to 15th century when the age of discovery began. But Bharat should effectively start from the 7th century before either of these people landed on our shores. Okay, and ask ourselves, what were the values that we subscribed to at that point of time? How can we treat them as relevant? How can we, let's say, contemporize them and make them relevant to the current period? Someone may say, how is 7th century relevant to 2020? I am saying 7th century was relevant to 1946 and 1947. Therefore, it continues to be relevant in 1971. It continues to be relevant in 2012 Kokrajhar riots. It continues to be relevant across the country when Bangalore is set ablaze. Therefore, 2020 or 2021 or 2040, that particular cutoff period will continue to be relevant. I am not taking a specific position with respect to what is the line that must be drawn between permissible free speech and impermissible free speech. I am saying, what is the framework within which this discussion must happen? Then we can have a separate discussion on the specifics of it.
Oh, that's a very interesting point to make. But then again, if you go back to this idea that we have to draw lessons from our ancient past, that is before the Abrahamic colonization, that we also entering a very contested territory. Because what was that framework? That is also very contested, sharply debated. Between different schools of thoughts of the ancient India, it was sharply debated. So how do we get around that problem?
Right. Now, there are two issues that need to be addressed, and there are two baskets in which I would respond to that particular question. We have to, first of all, recognize the fact that a significant amount of traditions and our repository of traditions were destroyed, burnt, pillaged, and devastated. Therefore, what you're left with is a truncated idea of your own past, and which has a bearing across the board. The only possible repository that continues to survive today, from which you can have some kind of reliable support, are schools of Shastric injunctions which are available in different parts of the country, where you have actual scholars of Dharma Shastras who are still available. Okay, and you can actually count the number of people who are proficient in Dharma Shastras. Okay, now therefore, the existence of such people ends up making the claim that it's a living civilization and a living tradition to some extent strong. That's one. Two, fortunately, not all parts of the country are still modernized. I use the word fortunately in a very considered fashion. I'm very, very happy that several parts of the country are not urbanized and they are not modernized. Okay, because that is where at least I have some link between the past and the present to allow me to decide what should be the future. That's point number one. Point number two, the reason why I think we are effectively stuck in this particular situation is, as Konrad else put it in 2012 in his article on why we should treat this as a civilization, is that most people end up talking of Bharat as a civilization as an academic point or as a talking point for the purposes of, let's say, public consumption. I don't think it makes sense to treat civilization as a talking point merely to get plaudits from people. Civilization is a lived reality. It is not a question of opinion. It's a question of fact. Okay. Culture is not a question of opinion. The existence of culture is a fact. What amounts to culture is an opinion. Similarly, the existence of a civilization is a fact. What constitutes the of that particular civilization is an opinion. Now, in that case, I would say Bharat must perhaps have a slightly more decentralized approach to certain issues, because I have said this even in the context of beef and other places. Certain places subscribe to very strong notions of why beef cannot be allowed. Those places must have the right to impose that through law, because ultimately law is enforcement of a specific form of morality, and typically morality of the majority. Similarly, you have to address these questions in a slightly more decentralized fashion. And if you do that, then Bharat's claim to being a so-called civilizational state and a Vishwa Guru and whatever it may be will at least be a reality. Otherwise, you call yourself a civilizational state, but when it comes to formulation of law and policy, you continue to behave like a nation state. That is the fundamental problem. So even in matters of free speech, even in matters of public morality, and every constitutional value which ultimately has a public morality underpinning to it, you have to treat yourself as a civilization, which should mean what is the geography, what is the culture on which this particular law is sought to be imposed? Is it consistent with the history of that particular place? That is a question that must be asked each time when we have this discussion. Mm-hmm. So when we have these discussions, we seem to have a Europeanized, centralized form of approach to it, where we say it must be applied uniformly across the board. That's precisely the reason why I have severe oppositions to the concept of a uniform civil code also. Okay, every aspect of universalism and every aspect of uniformity is nothing but a Europeanized, colonialized mindset that is at work, which treats India as a monolith, which it has never been, and it will never be, no matter what we do.
Mm-hmm. Well, that's an interesting point. I mean, many people have remarked that India and China are civilizations pretending to be nation states.